Welcome, everyone, back to another episode of the SERMAPod. I am the founder and CEO of SERMA, Rich Lenkov. SERMA is, of course, the Sports and Entertainment Risk Management Alliance. And in our continued effort to be at the forefront of breaking news in sports and entertainment, there is an important happening in the world of athletes unionizing. We will talk about that and much more with Trecia Moore from Hush Blackwell. She is senior counsel. She spent 14 years at the National Labor Relations Board, the NLRB, and currently practices labor and employment law at Hush Blackwell in Kansas City. Trecia, thanks so much for joining us on the SERMAPod.
Thanks. Appreciate it. And I'm glad to be here. Thank you.
So as I mentioned, and as many of our listeners and viewers have followed, the players at Dartmouth, student athletes, voted last week to form a union. Before we get into the significance of that, and it's very significant, talk to us a little bit about the history of this kind of movement when it comes to student athletes. How did we get to our present position?
Absolutely. I don't think we can talk about the Dartmouth decision without, and you can read the decision. And I should say this was a regional director's decision. This is not a board decision, not a position, or a decision from the NLRB. It is from a regional director. And so what that means is that, and actually, if you get online on the NLRB, you can link, there are links to almost every document in this case. So you can see all the information, get all the background and all the details about the case and actually where the case is going. But the employees filed a petition. Dartmouth said, hey, we don't think that under the act that NLRB, you actually have jurisdiction over these employees, and therefore we don't think these employees should be allowed to vote. Then the case went to a hearing. A hearing officer at the region heard it, and the regional director made a decision that said, guess what? You can go forward and vote. Vote took place. Same day as the vote, Dartmouth filed a request for review of the decision. And that same day, the board did respond and said, hey, we're going to go forward with the vote. But the board did not make a decision as to all of the issues included in the request for review. So I think it's important to mention that as well. So if you look at the RD's decision, what you're going to see is she relied on a couple previous cases. One, she looked at a case with the Northwestern football players, and she also looked at a Columbia University case, both private universities, just like Dartmouth. And so what you'll see in that decision is she said, hey, look, we think that the Dartmouth players are like the employees in Columbia. In the Columbia case, it was a 2016 case. And what happened there is graduate students, research assistants wanted to organize. It was the first time that the labor board actually said that these employees could organize, they could go forward, they could vote, and they did. Why was that determination made? Because the board said, look, they contribute to the university. They're bringing something to the school. The university will profit off of the research that they're doing and what they're bringing here. And in Dartmouth, the regional director said, look, it's very similar. We're making money off of these people, even though some might argue, the basketball team at Dartmouth isn't doing very well. Maybe we're not really making money off of them. But they are bringing something to the institution, something that we would not get if we didn't have them. And then as to the Northwestern University decision, that actually dealt with football players, so the Northwestern football players. And what was decided in that case, the board actually said that those employees actually, well, I shouldn't say employees, those student athletes voted. The ballots were impounded. They were never opened, so we don't know what would have happened there. But when the decision went to the board said, look, we do believe that the scholarship athletes, so not the walk-on players, but the scholarship athletes are employees under the National Labor Relations Act. We do not think that the walk-on players are, just because the employment exchange, their contribution, what they're getting isn't sufficient. But those who are getting scholarships, getting paid, getting all this free stuff, they are employees. But the board said, look, one, because of, I think what they called it was labor unrest. We're not going to allow them to vote because of labor unrest. It will cause too many problems. And quite frankly, The division that they're in is full of public universities. And for those of you listening, the National Labor Relations Act does not cover agricultural workers, independent contractors, and public institutions or public employees. So universities, public universities, teachers, law enforcement officers, individuals like that.
If you walk us through the process a little bit, what does that process look like? The application, hearing, is evidence submitted? How does that work for those of us that have not actually been involved in that process?
Yeah, absolutely. That's a great question. So first, an entity, employees, a union will file a petition for representation. I won't go into all the detail about union organizing and soliciting cards and of that nature. We can do that on another podcast if you want to. But bottom line, unions have to get at least 30% of cards signed by the proposed bargaining unit. They take those to the National Labor Relations Board, and I'll share with you, they never come in with just 30% because if they do, they're probably not going to win the election, because to prevail at the election, the union wins an election by 50% plus one. And for those of you who aren't aware, 13 employees voted for the union in Dartmouth and 2 voted against. So, I mean, almost unanimous, not quite. So once the petition is filed, the parties can agree to go forward with an election, or one side, typically the company, the employer, the university, can say, you know what, no, we don't think that this unit is appropriate. And that's what happened here in Dartmouth. And therefore, they then go to a hearing before a hearing officer who is an attorney or an agent of the National Labor Relations Board. And then the regional director will make a decision as to whether this is appropriate or not. And then that decision can be reviewed. The party who has no appreciation for the regional director's determination can say, I want to file a request for review over this decision. And that's what happened here.
So, Trecia, one of the players involved, in fact, the player rep, Kate Haskins, he said that or at least one of the reasons he was involved in this was because as a member of the union for dining hall workers, because he also works on campus in the snack bar, he made great strides in improving his employment condition. I think he doubled his salary. They got extra time off and other perks. If this is successful, can we what kind of benefits can we expect for student athletes? Because obviously that's different than working in the dining hall, and there isn't a straight salary involved, for example.
Well, Kate's going to have to make a tough decision because you can't work for one employer and be in 2 unions. So he's going to have to decide, am I going to be in the dining hall union? He may not even work in the dining hall anymore. I don't know. But, just edification purposes for everyone, you can't be in 2 unions when you work for one employer. So, here's the thing. Unions can be great in certain circumstances. Now, remember, I'm a management side attorney. I represent companies and organizations. I don't represent unions. I was in a union for many years when I worked as an employee at the National Labor Relations Board. So the union can make lots of promises to them. We're going to get you higher wages. We're going to get you better benefits. We're going to get you, in this case, let's say, better tennis shoes. You don't like the tennis shoes you have. You want to have laundry done every day. The bottom line is, what is the union going to get? Well, it's whatever the company or the employer or the university is going to agree to. What the union gets is a seat at the table. They get to sit down, they get to negotiate, but they only get what the company is willing to agree to. So I'm sure they're going to put things on the table like, fewer practice times. Who knows what they're going to put on the table. I was never a student athlete. I should admit that. Did not play sports in college or in high school. But really, it's whatever the employees want to ask for. We want more hoodies. We want different socks. We want more tickets. We want to stay at better hotels. We want better food.
Now, the rise of NIL, name, image, and likeness deals in the NCAA is obviously something that affects this issue greatly. We've covered that extensively on the SERMAPod over the weekend. We saw Caitlin Clark, right? Probably the most recognized student athlete in the country, man or woman right now. She won the Big Ten title. I think she was named most outstanding player for the 3rd consecutive time.
Shout out to Caitlin.
Amazing athlete. She'll go on to make less money in the WNBA, but that's a separate issue. We also saw Bronny James right on Saturday. I think he played for USC. His dad was in the audience. Those are two examples of players who are making enormous amounts of money now through the NIL situation. How much has that affected the issue that we're discussing, and how might that affect it going forward?
That's a great question. It's going to be up, if you are in a union, it's going to be up to negotiation. So when student athletes, employees, whatever you want to call them, when they elect a bargaining representative, so a union, guess what? They are giving the union the right to sit down and negotiate every single term and condition of employment. So right now, James Jr. and Caitlin get to decide those things on their own. Their agent is working for them. But when you have the union will sit down and negotiate all of that. This is what you're going to get. This is what you're not going to get. And so I question whether student athletes are thinking about that. Is that something that they want? Probably not. They're thinking about right now. They're thinking about what they need right now. They're not thinking about what's going to happen down the road. Collective bargaining agreements aren't a couple months. They don't last for a couple months. They last for years. Typically 3 years, 5 years. So a student may come in under a collective bargaining agreement and not even be there at the school for the entirety of the agreement.
All right. So where do we go from here, Tricia? I mean, the case it's on appeal. When will will it get to the Supreme Court? What's the anticipated time frame for this, and then how do you see this playing out in the future?
So couple things could happen. So the board did not rule on all of the issues in Dartmouth's request for review. So I believe that they will respond to that. I also think that what's going to happen is Dartmouth is very likely to engage in something called test cert. So they will test certification. What that looks like is within the next couple days, the region will issue a document called a certification of representative, certifying SEIU as the legal bargaining representative for the basketball players. After that, there is a legal documented obligation for the parties to sit down and start to bargain. My guess is Dartmouth is probably going to say, we're not going to sit down and bargain with you. I could be very wrong. I haven't spoken with their attorneys. I'm not saying this is going to happen. But most likely they will. They will say, we're going to test certification. We're not going to bargain with you. In response, the union will file an unfair labor practice charge with Region 1, the Boston office. That will be investigated. The region will probably say, yeah, we certified them. You're failing to represent them. We're issuing complaint. And then, that could go all the way up to the Supreme Court. Who knows? As they're processing the case, it could go to the DC Circuit Court or the First Circuit where Boston sits. So it's going to be a wait and see game as to what happens. But my guess is Dartmouth will probably try to test cert. I think from larger implications, a couple things that we need to be thinking about, those of us who work in this sphere, is not only does this decision say employees now can gain union representation, but when individuals are considered employees under the National Labor Relations Act, not only do they have the opportunity to join a union and engage in collective bargaining, but they also have what's called Section 7 rights. So Section 7 of the NLRA, the National Labor Relations Act, says employees also have the right to engage in protected concerted activity. And that is employees, typically two employees, not always, complaining about their wages, their terms and conditions of employment, their benefits. So what I think we're going to see is more student athletes engaging in protected concerted activity before we see more union elections. Because if I and a group of employees get together and we're complaining about our practice time, we're complaining about our shoes or the toilet paper in the locker room, those are terms and conditions of our employment. And if we complain about those things and then the school retaliates against us because of those complaints, that's unlawful. So if we get playing time taken away because we complained, that's unlawful. So I think those are ramifications of this decision that other people are not thinking about. So I think that is a definite consideration.
For sure. We're taping this a day after the Oscars. Last night, Jimmy Kimmel on stage, the host, mentioned the writer's strike, the actor strike. And he said, he celebrated how the actors remained vigilant and got some major concessions from the studios. We saw a similar, win by the union, the auto workers union. In fact, the head of that union was in the gallery for the State of the Union address on Thursday, was given a shout out by President Biden. This is another win, in this case, in the Dartmouth situation. Do you see this as a continued trend in favor of unions getting these major concessions, or is this just a blip on the radar? What's your thought on it?
This is not a blip on the radar. So for those of you who follow labor law, you know that Jennifer Abruzzo is the general counsel of the National Labor Relations Board right now. One of her, she puts out memos, GC memos. You can get on the labor board and find them about what her initiatives are. One of her initiatives is student athletes. And so I know on the podcast you've had people talk about the USC case. And so what she's trying to do there is find joint employer status so she can, not she, but the agency can have jurisdiction over public sector universities as well. So, we're seeing high rates of unionization. We're seeing lots of strikes going on. The general counsel of the National Labor Relations Board and the complement of the board right now are very, very pro-union, pro-employee. This is not going away. This is something that is going to continue, and employers, whoever you are, need to be vigilant about educating themselves about, if they want to remain union free or if they're open to having a union, but really what rights do they have and what rights do employees have under the National Labor Relations Act? Because if they're not doing that, they're going to find themselves faced with unfair labor practice charges and not really sure what to do.
Tricia, last question here on the SERMAPod. Does this mean the end of amateur athletics as we know it? Will our next generation of fans look back at this era and say, I can remember when student athletes weren't paid and weren't in unions?
I would say stay tuned on that. I am not comfortable. I'm not comfortable making a declaration about that, but stay tuned. Stay tuned and we will know.
You heard it here first. Got to follow the story. Got to have Tricia back on the SERMAPod. Trecia Moore with Hush Blackwell, Senior Counsel out of Kansas City. Thank you so much for joining us on the SERMAPod, and please come back and keep us updated on this very important issue.
Thanks, Rich. Appreciate it.